Hi everyone, today's unit that we'll be doing is Principles of Criminal Law. And the learning outcome we'll be doing today is Learning Outcome 2. My name is Shazia Khan. So before I go into Learning Outcome 2, I just want to give you a bit of an overview of what we've done in the last session, which was Learning Outcome 1. We looked at understanding the principles of actus reus and mens rea requirements of criminal offences. We looked at criminal conduct as an act against the state. We looked at actus reus and mens res and the definition, components and omissions of each one. We looked at the levels of mens rea, intention, recklessness, and we looked at the element of negligence and knowledge within mens rea. We then went on to look at real-world applications with reference to R and Cunningham case 1957 and R and G and another 2003. We looked at requirements of actus reus. We looked at actus reus as the guilty act, voluntary and involuntary acts. We went on to look at liability for omissions, causation, and novus actus intervenors with reference to cases. We also look at the requirements of mens rea, the guilty mind definition, the direct intention and oblique intention. We looked at recklessness with reference to case law and negligence. We looked at the elements, the relationship between actus reus and mens rea. And we looked at the relationship overview with congruence principle, complementary role, and the strict liability exception. We looked at a comparison and relationship between actus and mens. We looked at case examples, and we looked at the nature of criminal conduct and how it refers to the element of society. We looked at criminal conduct as an act against the state. So definition, the crimes and role of the state, enforcement of the law, examples, offences against the person, such as murder, manslaughter, assault and kidnapping, offences against property, which is theft, burglary and arson. We looked at public order offences, rioting, terrorism and corruption. We looked at the presumption of innocence and the legal framework around it, and the standard of proof and burden proof in criminal courts. And we also looked at the beyond reasonable doubt and the contrast with civil cases as well, so that they've got a bit of an example of the difference between civil and criminal cases. We looked at the high standard and how that's necessary in criminal cases, and why it's so important to look at the legal framework of the presumption of innocence and the criminal acts against the state, such as things like the crimes and role of the state, how they play a part in this in regards to the society, and enforcement of criminal law, like the agencies such as the police, investigation crimes, prosecutors, courts. So we looked at learning outcome 1 in regards to understanding actus and mens and understanding the principles around it and requirements of criminal offences. Now we're going to go on to look at the elements of understanding the classification of violent offences. So the indicative content for learning outcome 2 is looking at common law, assault and battery, occasional bodily harm, Offences Against the Person Act 1861, homicide, common law offence of murder, loss of control, Coroners and Justice Act 2009, section 52 and 54. We refer to Clinton 2012 and Diminished Responsibility. Key terminology, so what are the classification of offences in the UK? So you have a variety of offences ranging from common assault up to murder, and it encompasses the use of weapons such as firearms, knives, corrosion substances, murder and manslaughter, crimes that one person unlawfully kills another, and both are described as homicide. There's a video there that you can watch in your own time, and that looks at the different types of crime within the UK, and looks at the different offences that are available, things like maybe assault, robbery, murder, manslaughter, hate crimes, gang violence, domestic violence, drug crimes. So you can watch that in your own time. So understanding the classification of crimes. So because there are so many different crimes, offences, physical types of offences, they all have a different threshold for, the what divides them up, it could constitute physical force or threat of force against another person. So they range from minor offences up to the more serious offences, as we mentioned. Overview of violent disorder of violent offences. So violent crime covers, as we said, a variety of offences ranging from common assault to murder. It could be categories of offences against a person or public order offences, for example, assault, battery. It could be manslaughter, GBH. It could be rape, robbery, aggravated crime. So there is a different element of that in regards to that. Classification of violent offences. So the first one we're looking at is classification of violent offences is homicide. So, you have different elements of that. So you have murder, which is the element of taking someone's life with causing GBH. So you have homicide is the act of one person killing another person. It can be a non-criminal act or a criminal act such as murder or manslaughter. Murder, which we mentioned, is the unlawful killing of another person with the intent to cause serious harm. Manslaughter, the case for murder is the case of R.M. Vickers, 1957. There was an intent to cause serious harm was sufficient for murder. Manslaughter, the unlawful killing of another person without the intent required for murder. Manslaughter can be voluntary or involuntary. Attempted murder is another one, an unsuccessful attempt to unlawfully kill another person. So then we've got the assault offences. So we've got assault, and this assault covers a range of different actions, from using threatening words to a severe physical attack that leaves the victim permanently disabled. And offences of assault fall within the Offences Against the Person Act 1861, the Criminal Justice Act 1988, and the Crime Disorder Act 1998. And there are three basic types of assault. You've got common assault, actual bodily harm, and grievous bodily harm. So common assault is when a person inflicts violence on someone else or make them think they're going to be attacked. It does not have to involve physical violence. Threatening words or raised fists is enough for the crime to have been committed, provided the victim thinks that they are about to be attacked. Spitting at someone is another example of a common assault. And the case in regards to that is the Collins and Wilcock case 1984, which was the slightest touch could constitute battery if unlawful. The next one is actual bodily harm, which is ABH. This means that the assault has caused some hurt or injury to the victim. Physical injury does not need to be serious or permanent, but must be more than trifling or transient, which means that it must at least cause minor injuries or a pain or discomfort. Psychological harm can also be covered by this offence, but this must be more than just a fear of anxiety. And then the last one is grievous bodily harm, which is GBH, means that the assault has caused serious physical harm. It does not have to be permanent or dangerous. For example, a broken bone would amount to GBH. In some cases, a broken bone might lead to a permanent disability, but in others, it may heal without leaving any long-term effects. GBH can also include psychiatric injury or someone passing on an infection, for example, through sexual activity. Sexual offences is the next one. There are a range of crimes that can be considered as sexual offences, including non-consensual crimes such as rape or sexual assault, or sexual acts, crimes against children, including child sexual abuse or grooming, and crimes that exploit others for sexual purpose, whether in person or online. Crimes can occur between strangers, friends, acquaintances, current or ex-partners, or family members. The passage of time does not prevent the effective prosecution of sexual offences, and an increasing number of cases have come to the CPS in regards to allegations. The next one is, and the legislation that governs that is the Sexual Offences Act 2003. The next one is the public order offence. So public order offences are crimes that involve violence, intimidation, or other disruptive behaviour in public. They are tended to punish people who use violence or intimidation to interfere with society's operations. Examples of that would be things like riot, a violent public disturbance, affray, which could be a serious public order offence, threatening behaviour, so using words or actions to frighten or provoke violence, disorderly behaviour, acting in a way that disturbs the peace, drunk and disorderly, being intoxicated and causing a disturbance, and intentional harassment, causing alarm or distress. And the law that governs that is the Public Order Act 1986 in the UK. Next one is factors influencing the classification. So when classifying offences, key factors include the severity of harm used, the offender's level of culpability, intent and planning, the nature of the victim, so vulnerability, the context of the crime, the location, aggravating circumstances, or whether the offence was committed as part of a larger pattern of criminal behaviour, all of which contribute to determining the seriousness of crime and its corresponding legal classification. Key factors influence harm caused, offender's culpability, victim characteristics, context of crime, or the criminal past, criminal history. The legal framework and key legislation that deals with criminal law in the UK are things like the Offences Against the Person Act 1861, Criminal Justice Act 2003. The Act amended the law on police powers, bail, sentencing, and more. The Public Order Act 1986, Sexual Offences Act 2003, governs crimes including sexual violence. You could have the other one is the Criminal Police and Criminal Evidence Act 1984, which is part of the criminal legal framework. In conclusion, the classification of violent offence is criminal law is essential for ensuring appropriate charges, fair trials, and proportionate sentences. These classifications are based on the severity of harm, the mental state, and the offender, and the societal impact of the crime. By understanding these categories, the criminal justice system ensures the effective application of justice. 2.1 Outline of all violent offences. Violent crimes include any act that physically harms or threatens another person. And these include things like weapons or clear intent to cause harm. It could be things like, assault, battery, GBH. It could be homicide. Violent offences, so common law and battery. Common law assault and battery are separate summary offences that involve intentionally or recklessly causing someone to fear or experience unlawful force. Common assault involves causing someone to fear immediate unlawful violence. Can include unlawful touching without injury. Common assault can be tried in the magistrate's court, and the maximum penalty is 6 months in prison, a fine, or community order. The case example here is the case of Collins and Wilcock, 1984. Words or gestures can constitute assault. Next one is battery. which involves intentionally or recklessly applying unlawful force to someone. Can include any infringement of personal autonomy, no matter how slight the contact, and it can be tried in the magistrate's court. And then we've got the other one, which is Offences Against the Persons Act 1881, which looks at the element of section 47, which is assault occasional ABH, section 20, which is GBH, and section 18, which is GBH with intent. And we've got homicide offences. So you've got homicide is killing of one person by another. In England and Wales, homicide offences include things like murder, which are common law offence that can be modified by statute. You've got manslaughter, common law that can be modified by statute, but it's involuntary and voluntary. So for voluntary manslaughter, you've got the case of mitigating loss of control, the famous case of Alawalia, 1992. Involuntary manslaughter, gross negligence is the case of Adamoko, 1995. And then you've got elements of diminished responsibility, causation. You've got the thin skull rule, which is a case example of Blow, 1985, refusal to medical treatment did not break causation. We looked at the breaking the causation chain of causation in learning outcome 1, and the example is R and Peggett, 1983, using a human shield did not absolute liability, and medical intervention, the case of R and Cheshire, 1991, ordinary medical treatment did not break the causation. So you've got a summary table here that identifies the different offences with the definition, the key cases and the key points. So we've got assault, battery, ABH, GBH with intent, murder, manslaughter, thin skull rule and breaking causation. So please have a look at this in your own time, and the summary identifies the definition of each one with reference to cases and also the key points in them. A discussion of examples. So the case of R and Blow, 1985, the defendant stabbed a Jehovah's Witness who refused a life-saving blood transfusion due to religious beliefs. The court applied the thin skull rule, holding the defendant fully liable for the victim's death. Next case is R and Pageant, 1983. In this case, the defendant used a pregnant woman as a human shield during a shot out with police. The court ruled that the chain of causation was not broken as the police's actions were foreseeable response. The next case is the R and Cheshire case, 1991. The victim died after complications from medical treatment following a shooting, and the court ruled that the chain of causation was not broken on medical treatment and was not grossly negligent. In conclusion, violent offences encompass a range of different offences. The legal principles, including the thin skull rule and causation and cause, ensure accountability while safeguarding fairness in determining liability. Understanding these offences is really important for applying criminal law effectively in society. Defences of loss of self-control. So in criminal, loss of self-control and diminished responsibility are partial defences available to a defendant charged with murder. Are both partial defences, meaning they can reduce, this means that they can reduce a charge from murder to manslaughter if successfully argued, and they both require proof that the defendant's mental state was significantly impaired at the time of the crime, but they define the specific nature of impairment. So the first one we'll look at is loss of self-control. So loss of self-control, as we mentioned, is the element of focusing on a sudden extreme reaction to provoking situation, while diminished responsibility relies on reaction to provoking a situation. So that in the element of key points of loss of self-control is the triggering event. The defendant must have provoked the thing said or done that which constitutes circumstances of extreme grave character, causing a justifiable sense of being seriously wrong. And the loss of control must be sudden reaction, not a pre-planned act of revenge. And a jury must consider whether a reasonable person in the same situation would have reacted similarly. And the qualifying trigger in the loss of control must be caused by one or other factor. So fear of serious violence, the defendant feared serious violence from the victim against themselves or another person. Example, person who kills in response to a genuine threat of harm. Things said or done, or the victim's words or action cause the defendant to feel seriously wronged or provoked. In the case of R and Clinton, 2012, sexual infidelity alone does not qualify, but may be considered if combined with other triggers. Objective standard in this is the reasonable person at the same age, sex, and ordinary tolerance might have reached in the same way. Case of R and Kaplan, 1978, where a 15-year-old boy's age was considered in assessing the reasonableness of his reaction. Exclusions to loss of self-control, acting out of desire for revenge disqualifies the defence, and self-induced loss of control. So the legal defence of diminished responsibility was introduced through the Homicide Act 1957, which amended the law on murder. Before this act, the mandatory death penalty for murder in England and Wales was left little room for consideration of mental health factors. The Homicide Act created a new offence of manslaughter because of the diminished responsibility, offering a more nuanced approach to cases where mental impairment played a significant role. Elements of diminished responsibility. So certain criteria must be met to use the defence of diminished responsibility successfully in a court of law. The defendant must demonstrate at the time of the offence they suffered from abnormal mental functioning, and this substantial impaired their ability to understand the nature of their conduct, form a rational judgment, or exercise self-control. The first category, that of abnormal mental function, refers to a state of mind that deviates from the norm. This may include recognised mental disorders such as schizophrenia, bipolar disorder, or severe depression. In such cases, the court assesses whether the defendant's mental functioning was impaired to a significant degree, going beyond mere stress or emotional turmoil. The second and third criteria to prove diminished responsibility focuses on the extent of impairment. The defendant must establish that their abnormal mental functioning substantially impaired their ability to understand the nature of their conduct, from a rational judgment, or exercise self-control. This reflects a balance between recognising mental health challenges and ensuring that the impairment is substantial enough to justify a reduction in criminal responsibility. The defence of diminished responsibility is often used in cases of homicide, where the accused is charged with murder but seeks a conviction of manslaughter. The court plays a crucial role in evaluating psychiatric evidence and determining whether the defendant meets the criteria for diminished responsibility. Central to the defence in such cases is expert psychiatric evidence. Forensic psychiatrists and psychologists are often called upon to assess the defendant's mental state at the time of the offence. Their expert witness reports help the court to understand the extent of the defendant's mental impairment and its impact of the guilt. And this cases such as R and Goals 2016 and Deutschman 2003. In several landmark cases have shaped how the defence of diminished responsibility in England and Wales can be applied. In the case of R and Bryan, for example, it was established that abnormality of mental functioning does not need to mean a total mental impairment, emphasising the significance of degree of impairment. More recent cases, such as the Deutschmann case, which I just mentioned, clarified that the relevance of the defendant's voluntary intoxication in assessing diminished responsibility. In this case, a man killed his friend while drunk and was suffering from depression following the death of a close family member. The jury was asked by the judge to consider whether the defendant would have killed his friend if he had not been drunk and whether he was under diminished responsibility. A murder conviction against Deutschmann was quashed and replaced by a conviction of manslaughter. The defence of diminished responsibility in England and Wales is an important legal mechanism in cases where mental health plays a significant role in criminal conduct. While there's so many debates and criticisms about it, its role in the criminal justice system underscores that the evolving understanding of mental health and its intersection with legal responsibility. As society grapples with this complexity, ongoing discussion and potential reforms may shape the future application of the defence of diminished responsibility. So there's lots of talks and elements around that. Comparison of loss of control and diminished responsibility. So this summary, this table identifies the difference between each one. So you've got the legislation focuses qualifying factors, objective test, exclusion and outcome for loss of control and diminished responsibility, which you can have a look at in your own time. In conclusion, both loss of control and diminished responsibility are served to mitigate murder charges by acknowledging human emotions and mental health conditions. These defences balance the need for accountability with the recognition of mitigating factors, ensuring justice and fairness in the criminal law system. So the next one is 2.3, analysis of actus reus and mens rea of common law offences against a person. So there's common law offences against a person, which we looked at were assault and battery. And also we looked at the elements of GBH, ABH, and these analyses go under the section 52 and 54 of the Coroners and Justice Act, alongside with the claim of Clinton and Davies. So when we looked at actus and mens rea, they're the building blocks of criminal liability. Both must be proven to the criminal standard for the defendant to be criminally liable. Offences can be committed by failure to act, but only where they're capable of being committed by omission and defendant is under a duty to act. So common law offences against the person. So common law assault is an act by where a person intentionally or recklessly causes another to suffer, apprehend immediate unlawful violence. And we're going to look at assault and battery in regards to that. The first one is assault. So in the UK, assault is defined as an action that intentionally or recklessly causes someone to fear immediate and unlawful violence. It can also include unwanted physical contact or verbal abuse. And the element of that is in the case of R and Ireland, 1997. Types of assault are things like common assault, ABH, GBH, aggravated assault and verbal assault as well. The next one is battery. And battery is the unlawful application of force to another person without their consent or other legal justifications. It can include any infringement of personal autonomy, even if the contact is slight. Cases of battery can include instances in which a person is pushed, slapped, or even spat at. When might a person be charged with ABH instead? So this is often section 47, which refers to the Offences Against the Person Act 1861. And case example for that is the Collins and Woolcock case, 1984, where the police officers unnecessarily grabbing a woman, grabbing of a woman was deemed battery. So GBH. So GBH offences are taken very seriously within the UK and carry significant legal implications. Individuals convicted of GBH can face substantial penalties, including lengthy prison sentences, substantial fines, and a criminal record that could lasting consequences on their personal and professional lives. The severity of the punishment often depends on factors such as the extent of the harm caused, the intentions of the perpetrator, and any aggravating or mitigating circumstances surrounding the offence. GBH offences can arise in various situations, ranging from physical altercations to deliberate acts of violence. Common scenarios where GBH charges may be brought include assaults with weapons, domestic violence incidents, and attacks resulting from heated arguments or disputes. It's important to recognise that GBH charges can also stem from accidents or incidents where the perpetrator did not intend to cause harm but acted recklessly or negligently. Individuals facing GBH charges have the right to mount a legal defence against the allegations against them. And is governed by sections 20 and sections 18 of the offences. So these type of offences are covered under the Offences Against the Person Act 1861. Section 18 is you could face up to life imprisonment with intent, and section 20 is inflicting GBH recklessly. Mens rea section 20, intention or recklessness, and case examples are the case of R and Mowat 1967, which was reckless sufficient for section 20 GBH, and R and Belfon 1976, which was specific intent required for section 18 GBH. Next one is actual bodily harm. So actual bodily harm is assault or battery that causes harm to a person's body. The harm does not need to be serious to be classed as ABH. However, it does not need to be more significant than a push or a shove. Harm that consists of bruises, scratches, or bite marks would be sufficient enough to be classed as ABH. But the most important factor when convicting an individual of ABH is that the offender only needs to intend to apply unlawful force, not intending to cause injury. So if you push results in someone hitting their head against a wall, it is more likely to be ABH than GBH, or common assault, because the intention was to use unlawful force rather than causing a head injury. ABH can be tried in either the Magistrates' Court or the Crown Court and carries a maximum penalty of 5 years in prison. Mens rea for ABH is intention to or reckless as to the initial assault. Case example is R and Miller 1954, which defined ABH as harm interfering with the victim's health or comfort. So the next one is looking at legislation, which is the Coroners and Justice Act 2009. So the aim of the 2009 Act were to put the needs of bereaved people at the heart of the coroner service, for coroner service to be locally delivered within a framework of national standards, for coroner national standards, and to enable more efficient system of investigations and inquests into it. It's section 52, diminished responsibility, and section 54, which is loss of control. And case examples are R and Clinton 2012, sexual infidelity alone, is not a qualifying trigger, but it may be considered in combination with other factors. And R and Doe's 2013, which looks at loss of control, does not need to be immediate or self-induced provocation, may disqualify this defence. So the summary table looks at the offences, which is assault, battery, ABH, GBH, and GBH with intent, loss of control, and diminished responsibility with reference to what the actus rea is for each offence, and the mens rea for each offence, and the key cases with reference to it. So that table identifies the different types of offences, but also looks at what's the guilty act of that, so the actus rea, what's the mens rea, and the key cases for that. You can have a look at that in more detail in your own time. Discussion of Clinton and Dawes. So in Clinton 2012, the defendant killed his wife after discovering her infidelity and talks about his depression. The ruling in this case was sexual infidelity alone is not a qualifying trigger, but in combination with other factors, it can be considered. This case highlighted the nuanced application of loss of control. In the case of Dawes, 2013, the defendant attacked his wife's lover, resulting in death, and claimed loss of control. The ruling in this case is that loss of control does not need to be immediate. However, self-induced provocation may disqualify the defence. So in conclusion, the actus and mens rea of common law offences against the person reflect the balance between physical acts and mental intent. The introduction of statutory defences like loss of self-control and diminished responsibility under the Coroner's Act and Justice 2000 now ensures that human frailty and mental health conditions are considered, promoting a fairness within the criminal law proceedings. So analysis of actus reus and elements of mens rea defined in elements for murder. So like we said, murder is an unlawful act of killing a human being with malice aforethought, and it requires prosecution, two components. It requires the actus and the mens. So in the crime of murder, the actus refers to the physical act of killing, meaning the unlawful taking of a human life, while the mens rea refers to the mental state of the perpetrator, which in most jurisdictions requires an intention to kill or cause GBH to the harm, essentially the guilty mind. The unlawful killing is the core element of actus reus, meaning the defendant must have directly caused the victim's death through voluntary act or omission where legal duty existed. The prosecution must prove a causal link between the defendant's actions and the victim's death. In certain situations, failing to act where there's a legal duty to do so, like a parent neglecting a child, can constitute the actus reus of murder. Actus rea of murder. So the law of murder, as we said, is a common law definition where, someone unlawfully kills another person. The actus reus of murder, therefore, consists of the unlawful killing of a human being in the King's peace. So you've got to take that into account when you look at the actus and mens of murder. So what's the actus rea of murder? So it's the key elements of that unlawful killing, the causation and factual causation, which is the case of R and White 1910, and legal causation as well. So you've got to look at them elements when you look at the element of a murder. So, was there any intention there? What are the elements that have been identified when you talk about murder? And what is the actus rea as well when we look at it in regards to murder? So, making sure that you're looking at the actus rea of murder, and how it is established as well. So in regards to the case of R and White, the defendant's attempt to poison his mother failed to cause her death as she died of a heart attack unrelated to the poison. And that looks at factual causation. And then you've got the legal causation, and the case example is the case of Aaron Paget, which looked at using a human shield that resulted in the victim's death did not break the chain of causation. The next one is the element of death of a human being, and the case of AG reference, and also under the Queen's Peace, and making sure that you're looking at the element of murder when it comes to it. So the specific actus required to establish criminal liability varies dependent on the case. As we mentioned, in murder, the actus would be the physical killing of another person, while in a drug possession case, the actus would be the possession of an illegal substance. So the mens rea of murder. The mens rea of murder refers to the mental state required to establish criminal liability. So it would look at the intention to kill or cause GBH, and it would be the guilty mind. So it's a mental element of crime and the guilty intention to cause criminal result. And here we'd look at the key elements of mens rea, which are intention, which looks at the prosecution must prove that the defendant had the intention to kill or cause GBH. And the direct intention is the case of R and Vickers 1957, which established that only an intention to kill or cause GBH is needed to establish the mens rea of murder. And then oblique intention, the case of R and Woolin, which is the court held that the intention could be inferred if death was a virtual certainty. And then malice aforethought, which is elements of refers to defendant's culpable mental state. It includes express malice, intention to kill, or implied malice, intention to cause GBH, which results in death. The application of actus reus and mens rea in some comprises actus and mens is a foundation element. Actus is the guilty act and men is the mens rea, as we mentioned. Actus and mens are the building blocks of criminal liability, as mentioned earlier. Both must be proven to the criminal standard for the defendant to be criminally liable. Causation and concurrence are essential elements for criminal liability, with causation determining if an act caused harm, and concurrence requiring both actus and mens rea to occur simultaneously. So to secure a murder conviction, the prosecution must prove that the defendant's actions unlawfully caused the death of a human being, which is the actus reus, and the defendant acted with intent to kill or cause serious harm, which is the mens rea. Both elements, like we mentioned, should be concurrent with each other. In general, consists of two elements. There must be concurrence between the guilty mental state and the guilty act. This means that both elements must occur at the same time, or essentially at the same, must occur at the same time or at an essentially same time. The core examples in regards to that are the case of Aaron Gibbons and Proctor, 1918, where the actus reus was a father and stepmother starved a child to death. The mens rea was intentional neglect demonstrated intent to cause serious harm. The outcome was both were convicted of murder. Another case is Aaron Cunningham, 1981. The actus was the victim's death was caused by the defendant's violent assault. Mens rea was intention to cause GBH, sufficed for a murder conviction. And the case of Aaron Blow, 1975, where the actus reus was the defendant's stabbed the victim who refused a life-saving blood transfusion due to religious belief. The mens rea were intention to cause serious harm, and the outcome was a thin school rule was applied in this case. So a summary table looks at the element of unlawful killing, causation and human being and the Queen's Peace, looked at the actus reus, the mens res and the key cases with reference to the element of unlawful killing, causation, human being and Queen's Peace. So you could have a look at that in your own time. The elements of actus reus and mens rea for murder ensure that liability is assigned only when both physical and mental culpability are present. Through principles like causation and malice, the law balances the gravity of offence with a fair assessment and looks at each individual case separately. So now that we've finished learning outcome 2, I just want to give you an overview and a recap on what we've done in learning outcome 2. So you've got a better understanding. So we looked at understanding the classification of violent offences. We looked at elements of different violent offences. We looked at the overview of violent offences, such as offences against a person, public order offences, and we looked at classification of violent offences, such as homicide offences, the different types, murder, manslaughter, involuntary, corporate manslaughter. We also looked at assault offences, which are common assault, ABH and GBH. We looked at sexual offences as well, and public order offences. We also looked at factors influencing the classification, such as the level of harm, intent and circumstances. We looked at the legal framework and key legislation, such as Offences Against the Person Act 1861, Criminal Justice Act 2003, Public Order Act 1986, Sexual Offences Act 2003, and looked at elements of that. We looked at outlining all violent offences and looked at common law and offences, assault and battery, offences against the person, section 47, section 20 and section 18, with reference to case law. We looked at homicide offences, murder, manslaughter, causation, breaking the chain of causation and medical intervention. We then went on to look at some defences of loss of control and diminished responsibility, and looked at the common law offence of murder, and looked at the element of loss of self-control, elements of loss of self-control, such as qualifying triggers. We looked at the diminished responsibility, such as abnormality of mental functioning, substantial impairment, causal link and recognised medical conditions. We looked at analysis of actus reus and mens rea of common law offences against the person. We looked at assault and battery. We looked at GBH and ABH. And we looked at the legislation, which is the Coroners and Justice Act 2009, with reference to section 52, which is diminished responsibility, section 54, loss of control, and looked at case examples such as Aaron Goals, Aaron Clinton 2012, and Aaron Dawes as well. We looked at elements of discussion of the elements of Clinton case 2012, and Dawes case 2013 as well, with reference to the facts of each of them cases. We then went on to 2.4, looked at the analysis of actus reus, mens rea elements for murder, and we looked at the application of actus reus and mens rea, how to secure a murder conviction. We also looked at case examples highlighting actus reus and mens rea, such as Aaron Gibbons and Proctor, Aaron Cunningham and Aaron Blow. We then went on to look at the element of unlawful killing, causation, human being, Queen's Peace, with reference to actus and mens for each one, and reference to cases such as Aaron Vickers, Aaron Gibbons, Aaron White, Aaron Woolen and Aaron Blow. So that was just to identify different elements of unlawful killing, causation, human being and Queen's Peace. So we then went on to look at the key elements of mens rea and malice aforethought. And then we finished learning outcome 2 in regards to identifying the different summary tables, so you can look at them in your own time. And also these are the references we've used for today's session that you could have a look at, and there's some links there that you could have a look at in your own time as well. Also, what we have done is we've looked at preliminary, which is looks at some ebooks and additional reading on Moodle that you could go on to have a look at in your own time. And there's a CPS document there on the different table of offences and the different offences that are within the UK, in regards to what offences are the homicide offences, what the penalties are, what the elements of sentencing are for each one on the CPS website, and also looks at the analysis of actus amends for each one. It also looks at the different types of offences and what sentences they carry in regards to it. So you can have a look at that article in your own time. Any questions you have, email learnerwork@ukvarsity.co.uk. And the submission of the assignment is to be done on learnerwork@ukvarsity.co.uk. And you have assignment submission is 2 weeks of the completion of the unit and its delivery. So we've been through learning outcome 1 and we've done learning outcome 2. These will all be recorded and put onto Moodle for you with the unit specification that you could refer to, and also you could have a look at the assignment brief, which will be available on Moodle as well, that you can have a look at. Any sort of additional reading and some links are available for you to read to help you with your assignment discussion. If you have, again, any questions or any queries about anything, email learnerwork@ukvarsity.co.uk. Thank you for attending today's session, and the next learning outcome will be learning outcome 3. Thank you.